We're good.
Okay, good morning, everyone. I'm going to call to order the Tuesday, November 28th meeting of the Medical Records Requests and Records Fee Working Group. Does my co-chair have any introductory remarks?
Thank you, everyone, for attending today. And I hope we have a lively discussion.
All right, thank you. We'll first start then with an approval of the minutes from November 14th, if I could have a motion to do that.
So moved.
Thank you, Mr. D'Amico. A second?
Second.
Thank you, Rep. Conley. Any discussion on the minutes? Seeing none, we'll proceed to vote. All in favor, say aye.
Aye.
Opposed?
Aye.
Motion carries. All right, next item on our agenda is discussion of legislative proposals. We have two issues at play here. We have the normal record statute, and then we have a workers' compensation specific statute. We've asked for proposals from everyone, and we did receive one. So why don't we start out with Mike D'Amico, if you don't mind, why don't you take us through what you have submitted?
All right. So the current statute on the books, putting workers' comp aside for a moment, is 20-7C. And that's the statute that sets the medical records fees. The subsection that's really at issue is subsection D. So the proposal that I submitted is limited to subsection D. What I did was I took a look at the version of the proposed bill that passed out of the Public Health Committee last session and incorporated most of that language in the middle, where it talks about the cost per page and the reasonable cost-based fee under federal law. And I'll go through that in a moment. And then Representative Blumenthal had submitted an amendment to that draft bill. And so I took a look at that as well. And I tried to blend those two versions and then made a couple of other edits based on some thoughts that both Rick Silver and Kathleen Nastri had when we went through the draft bills. So what I'm looking at, and I don't know if does everyone have a copy of this? Was it circulated? I think it was circulated.
Yeah, it was circulated earlier this morning. So, I apologize for the short circulation notice on that, and understand that everybody may not have had a chance to look at it, but go ahead and continue, Mike.
All right. So the portion of the bill that we submitted that's underlined, if you have it in a black and white copy, or if you have it on the digital version, it's underlined, and in red are the changes, and the crossouts obviously are changes as well. The black, which doesn't have any crossouts or underlines, is what wording currently exists in the statute. So the first thing on the third line that we did was we wanted to make it clear that the record that's produced has to be complete and legible. We added in the word color copy because oftentimes in particularly medical malpractice cases, it becomes very important to make sure that we're seeing the record in color. Typically, that's a non-issue. I find it to be a non-issue as long as it's an electronic format, which most of the records are these days. If for whatever reason it's not an electronic format and it has to be printed as a color copy, we understand that there may be a slightly greater cost associated with that. And, we can have a discussion about that if it's a paper produced copy. So that was the first change that we made. The second change on the fourth line that we made is we crossed out X-rays and simply changed it to imaging studies, because when this statute was originally passed, things like MRIs and CT scans and those kinds of things, I don't think were in a lot of people at the forefront of everybody's imagination at the time. So we broadened that to simply say imaging studies, which would cover any type of an imaging study, not just an X-ray. And then we deleted the section about contact lens specifications, because honestly, we just felt it was unnecessary. It's included in the broad wording of the copy of a patient's health record. I wasn't involved in the drafting of this when it was initially passed years ago. But my suspicion in speaking with Rick, both of our suspicions, is that was some particular issue that had arisen and wanted to be put in at the time, but don't feel it's necessary because it's already included. Then we added in records of any other healthcare providers. And by that, what is meant is oftentimes in healthcare providers' charts, there are records of other healthcare providers. For instance, if you're dealing with a PCP, for instance, you may have notes from a cardiologist or notes from a pulmonologist or notes from an oncologist. And as long as it's included in their record, we would want the complete record. And so we just wanted to make it clear, records of any other healthcare providers. So the way that first sentence would read now with the changes, skipping the first line or so, it says, shall furnish to the person making such request a complete and legible color copy of the patient's health record, including but not limited to bills, imaging studies, copies of laboratory reports, records of any other healthcare providers, prescriptions, and other technical information used in assessing the patient's health condition. And then we added in a sentence that was not there, and this has to do with the electronic format issue. And so the added verbiage is, the written request shall specify paper or electronic format. And if requested to be produced in electronic format, then the health record shall be produced in electronic format. We made it clear that by adding in the following sentence, nothing herein shall require a provider who does not maintain health records in electronic format to produce records in electronic format. And that was a concern that was expressed, although most healthcare providers are on an electronic health record system, some are not. And we don't want to burden those healthcare providers with the expense of having to adopt some electronic formatting system when they're not set up to do that. So we made sure that we addressed that. The next sentence was in the next couple of sentences are in the initial text of the statute. So that had to do with a situation where a patient may bring original records to a healthcare provider and then wishes to have those original records back. There was nothing we needed to do with that. So then as it came to the actual charge, the cost, what we added was, except as provided herein for an expedited copy, and we'll talk about that later on as we get to the end of this, no provider or other party in possession or control of a patient's medical records. And the reason we added in or other party in possession or control of a patient's medical records is because most of the time when you're dealing with institutions, hospitals, nursing homes, these type and oftentimes others, large multi-specialty groups, it's not the healthcare provider themselves that are producing the records. As we know, it's a vendor like Ciox or others that are producing the record. And so we added in the verbiage or other party in possession or control of a patient's medical records. And then it says shall charge a patient, patient's attorney, or patient's authorized representative. And that is to address the issue that arose and continues to be somewhat of a dubious issue in the federal legislation. And we wanted to make it clear that a patient's attorney or otherwise authorized representative could request the record and cannot charge more than, and the first part is already in the statute, 65 cents per page, including any research fees, handling fees, or related costs, and the cost of first-class postage, if applicable. That's already there from years gone by. And the portion that we added in was, or two, a reasonable cost-based fee determined under any federal law, regulation, or administrative guidance regarding such law or regulation, regardless of whether such reasonable cost-based fee otherwise applies to request by the patient, also referred to as the patient rate, patient's attorney, or patient's authorized representative, whichever is less. Now, we could have simply put in the actual citation to the federal regulation, but didn't want to do that because as federal regulations change and numbering systems may change, then it would require an amendment of the statute to deal with that. And so instead, this verbiage that I just read was the same verbiage that was included in the proposed bill that passed the Public Health Committee last year, as well as adopted in the amended version that Representative Matt Blumenthal, had proposed. The reason we wrote in whichever is less is to address the issue where you have a healthcare provider's record, let's say it may be 2 pages, we didn't want a situation where you have 2 pages and it costs $1.20. And then we get into a situation where you're actually paying more, for the record than you would otherwise pay at 65 cents a page. So we made it clear that it's whichever is less. And then we added in the word complete. So for furnishing a complete health record pursuant to this subsection. And then there was an exception in the original statute, which we left, that applies to imaging studies. And so we just modified it slightly. So it says, except such provider or other party in possession or control of a patient's medical records. And that's to make it consistent with the verbiage that I mentioned before. May charge a patient the amount necessary to cover the cost of materials and supplies for furnishing a copy of an imaging study not reproducible in electronic format. So these are those situations where you have a plain X-ray, it needs to be reproduced, and it's not in electronic format, or an MRI, it's not reproducible for whatever reason in electronic format. And we just wanted to make it clear that there is an exception, that there can be an additional charge for cost of materials and supplies if that's necessary. And then the final change that we made had to do with an expedited copy. And so the statute as it currently reads says a provider shall furnish a health record requested pursuant to this section within 30 days of the request. And in order to provide for an expedited copy, we added in the verbiage, unless an expedited copy is requested due to an impending statute of limitation or repose, in which case an expedited copy shall be provided within 10 days. And an additional handling fee of $10 may be charged in addition to the fees specified in this subsection. We added in a sentence, if an expedited copy is requested, it must be accompanied by a statement that a statute of limitation or repose may expire within 120 days of the request. So I adopted the amendment that Representative Matt Blumenthal had proposed for the fee, the handling fee. That was the proposal in his amended bill. I forgot who had mentioned a concern, but somebody at our last meeting had mentioned a concern that if there's a provision for an expedited copy, then everyone's going to request an expedited copy. And so we wanted to restrict it by addressing that concern to situations in which the statute of limitations or repose may expire within 120 days, and a statement would have to be provided to that effect, presumably a good faith statement that situation is in play. So those were the proposed changes to the existing statute. In summary, it was designed to make sure the copy we received was complete and legible. A color copy is always necessary, particularly in medical malpractice cases. We broadened X-rays to include imaging studies. We broadened records to include records of other healthcare providers that may be contained in the record set that provider has. We brought it to modern times by making sure there was a provision in there about acquiring records in electronic format. We made it clear that we're not requiring a provider who doesn't have an electronic system to adopt one. We made it clear that vendors as well as healthcare providers are bound by these charge restrictions, and made it clear that not only a patient, but a patient's attorney or representative could make the request. That if it's a paper copy, it can't be more than 65 cents a page. If it's an electronic copy, it has to be in line with federal law, whichever is less, and allowed for an additional charge for imaging studies if they couldn't be produced in electronic format and additional materials or supplies were needed, and made a provision for an expedited copy for those situations where there isn't time to wait for what these days turns out to be 30 days, 60 days, 90 days, sometimes a lot longer to get a record. And before you know it, we don't have time to investigate a medical negligence claim. So those were, in summary, those are all the changes. I'm happy to address any questions at your pleasure, Representative Quinn.
Okay, thank you, Mike. I appreciate that. Before we get into questions, I know Rick and Kathleen worked with you on this, and I want to thank them for that. Do either of you have anything you want to add at this point?
Let me just pipe in for Kathleen. She's trying to handle two things at the same time, so she is on mute. I don't know if she's available to say anything, but she might be. Okay. I just wanted you to know that.
Okay, thank you. And Rick, did you have anything you wanted to add at this point? You're on mute, Rick. And I think that was a no, but.
No further comment. Mike did a great job.
Okay, thank you, Rick. All right, then we'll start with Jennifer.
Thank you, Representative Quinn, and thanks, Mike, for walking through that. I think Representative Quinn pointed out that some of us have only had this for essentially an hour, so I apologize. But I do have some clarifying questions and a couple of comments that might help us move forward. My first question is relative to the statute of limitations and counting the 120 days. And I know for some of this who are or were litigators, a little bit of inside baseball, but are you counting from the natural expiration of the statute of limitation, or are you counting from the 90-day extension?
That's a very good question, and I thought about putting that in there and didn't. I didn't want to overcomplicate it, but it is a matter of clarification that would make good sense to put in. It was intended to be the natural expiration of the limitation, not the tolling period.
Okay. I appreciate that, but so not, and I don't want to become argumentative, but conceptually, if the clarification on that were the other way, you'd essentially be getting, I'll say 30 extra days from the 90 days to make the review. I'm curious as to that, and certainly the three of you have a pretty good coverage on this that's, I think, representative. How often does it happen that you can't bring a case because you couldn't get the record in time? Or better said, perhaps it's better said for this group, what do we expect the frequency of the use of that proposed clause to be? Is that once a month, 800 times a year? Do you have any idea what the uptick in requests would be if you had the facility to expedite requests because of the looming expiration of the statute of limitations?
You want to comment on that, Rick?
It happens pretty frequently. It happens pretty frequently because to bring an action in Connecticut, you must have a physician indicate that there is a good faith declaration that there is negligence. So in order to do that, my experience is that a physician will not give that opinion unless they see a full copy of the records, both the physician's records and the hospital records. So, and to get an expert, it takes time. For the expert to review it, it takes time. And I have on occasion refused to take any case because of the limitation. I don't want to accept the case and tell a client that we're going to bring a case if I don't have enough time to properly do it. So that it has happened. It happens in a way on a yearly basis, somewhat frequently. I think clients think that they can go to 5 days sometimes before the statute. They're generally not knowledgeable about the 90-day extension, but it creates a lot of pressure, and I don't want to, my firm doesn't want to undertake a case unless we can properly analyze the case and bring a case that is got validity. And you can't bring a case with validity unless you have the full record, both from the physician or physicians, from the radiology standpoint, and the complete hospital record.
So I appreciate that, Rick. I don't think that answered my question, but I guess we can ask you guys to go back to the shop. If you've got some answer on that, that would really help our vision into that. Obviously, you don't have to. My next question is about the color. So some clarifying language.
I don't want to reveal any personal, I'm sorry. I don't want to reveal any personal cases, but you've asked me a general question. I've given you a general answer that it happens, and it's disturbing it happens because of the inability to get records.
So
Yep,
let me,
I just asked the frequency, and if you don't know, you don't know. So the other question I have is about color, Mike. I appreciate the concept. I agree with you. Even back in the days when we had only paper, it does make a difference if you see it, right? There, you can see different things. But I'm concerned that there are certain systems that either don't print the right color, and I do think it isn't a little bit of cost. I know you alluded to, you recognize there's some extra cost. So I wonder if we couldn't work on that a little bit. Something about feasibility or availability. I'm just going to put a pin in that. I don't need you to explain. I get that concept. I'm just not sure it's as ubiquitously available as you described. So the big ticket item here appears to be that your changes would remove what you described as confusion at the federal level. I'm not sure how much confusion there is with the HIPAA issue. We call it the SIOX case, right? So for those who aren't deeply embedded in this, the HIPAA makes a distinction between the patient asking for their record and what rules on fees and timing apply to that versus anybody else, including the patient's attorney. So what this change would be doing is for Connecticut, making it so that the attorney is the same as the patient. That's not actually the federal law right now. And that's not a confusion. That's literally not the federal law right now. So that's just something that we need to be clear about. Additionally, even with that switch, if we get to that point, it looks like it would need some more really deep clarity on that it still needs a HIPAA compliant authorization just to create no further delay. So even if we get to the point, which I'm not conceding, that an attorney's request is the same as the patient's request, you'd still need a HIPAA compliant authorization because the language in 27C is actually predates HIPAA and it's a little messy. So I would recommend if we're going to fix it, we fix it all at once. And then I am concerned about this vendor language. I hear what you're trying to do. I appreciate what you're trying to do so we don't create this parallel universe where the SIOX type companies are doing something else. But under HIPAA and under, I think, any part of Connecticut law, the vendor can't do anything without the principal, in this case, the covered entity's instruction. So I am concerned about that language. I would love to find a way to get at it, but I don't know that this is it. I don't think the state of Connecticut, I think this is actually preempted by HIPAA because the covered entity holds the ball on that. And I don't think the state can overcome that. But that is something that can be worked on. I understand the concept. I'm just not sure those are the right words under Connecticut law to do that or under HIPAA. And I appreciate it. I think it's comprehensive. But again, if we're going to do it, I feel like we should clean up all the stuff that doesn't make sense Other than if we don't do that, we're going to keep coming back at it. So I appreciate you letting me comment.
May I respond, Representative Quinn?
Thank you. Yeah, go ahead, Mike.
I appreciate your comment about the color copy, and we would need some further thought on that, to the extent that there might be some systems that don't have that capability, or that the expense may be a little bit greater. We would need to have some, better understanding of that. In terms of your frequency question, without being able to give you specific statistics, because I haven't maintained those, from my own experience, if I were to give you a percentage, and don't hold me to this, I would say we may reject, maybe 10 to 15% of med mal cases simply because we don't think we have enough time to get the records, given the delays that we typically experience in the records, and we have to build into that timing for an expert to review it. And that is a lengthy period of time. It's very difficult and oftentimes impossible to ask a respected medical expert to set aside what they're doing in their clinical work to review records. And so it would be unusual for someone to review records, within a short period of time, say within 30 days. Generally, they ask you, they say, is there a deadline looming that we need to know about? And if we were to tell them, the deadline is 3 weeks from now, they'll be like, sorry, pass. And so, most of the time, if we see a statute that's about to expire, 3 to 4 months down the road, we're very reluctant to investigate that, given the time limitations involved. Have there been some times that we've done that? Yes, but generally we're reluctant, and I think that applies oftentimes with the firms here in Connecticut that get involved in those cases. Now, how frequently this provision may be utilized where we actually do investigate it, it really depends on how quickly someone believes there was medical negligence and they contact you. Now, oftentimes they have an awareness right away, and we may get a phone call very quickly, sometimes within a week, within a month. And I would say that most of the times, we're going to get a phone call within the first year. I would say, I hesitate to give statistics, but I would say it's probably greater than 50% of the time. But there are oftentimes still that we get calls, well beyond the first year. And there are some times where there isn't really a realization, or the damages aren't clear enough. And so sometimes what happens is somebody calls and the negligence seems clear, but the damages haven't become clear yet. And so we have to wait to see whether or not it's practical. And then that brings us into a period that's much closer to the limitation period than it otherwise might be. So it is getting an expedited copy is an important concern when those situations arise. I wouldn't say that it certainly isn't the majority of the time, but it is some percentage of the time. It might be a smaller percentage of the time, but it happens frequently enough that it's important, because there are merit-based claims that can't be pursued in the absence of an appropriate amount of time. I did want to ask you for a couple of clarifications, just so I fully understand, Jennifer, what the concern is. And I appreciate your thought about the lack of confusion in the federal law. Regardless of whether there's confusion or there isn't confusion, how to address the federal law has been a stumbling block for litigators for many years now, and it has become very problematic because trying to get the records at a reasonable rate with the patient having to request them and then trying to get them in a reasonable time and making sure that they're thorough is difficult. But you had mentioned a concern about a HIPAA compliant authorization. And so if we were to put some language in here that would address your concern about a HIPAA compliant authorization, if you were to take a stab at telling me where that would be appropriate to insert, where would you say?
Yeah, I'm going to go back to the shop and work that out. I don't want to get it wrong, but I appreciate what you're saying. And I am not one of the attorneys who thinks that it has to be the patient and go through the kabuki theater of doing that, but I'm in the minority on that. So what I'm trying to figure out is a pathway to make it so that the argument folks make, and I suspect the third-party vendors are going to make, is that it's the same, right? So the concept under Connecticut law is meant to be, it doesn't matter who sends you the letter. If the patient has authorized the release, then that's the same as the patient asking. So I think that's what you're saying, and I think we can find the right words for that. I don't know that it'll be airtight because folks are still going to use the argument on the federal law regarding the fees under 45 CFR 164.524 versus 508. So I'm making a note to be sure that I look at where that would be least confusing, but I appreciate if that's what you're trying to do, that makes sense. I don't know that that isn't going to bring a lot of debate.
All right, and then my last question, just for my own clarification, we had used the verbiage or other party in possession or control of the patient's medical records. And your thought was, or your comment was, that it still requires the provider's instruction or consent, so to speak. If we left it simply no provider shall charge a patient, the ambiguity that's created is, well, it's not the provider that's charging the patient, it's the vendor that's charging the patient. So I appreciate your commentary, and certainly we want to get the verbiage right. So if there's some suggestion that you have in that regard, I'd be all ears to figure out how best to word that, as long as it covers providers and vendors.
I appreciate that. So and again, off the top of my head, and again, I will fine tune. I think it needs to be somewhere else. Like it's nothing herein will, makes it any different if it's in the hands of a third party. But the problem here is this is a law about your obligation as a provider to produce records in certain amounts of time that is meant to coincide with the federal law. And that isn't how any of that works. So I appreciate what you're saying. I'm putting 2 notes down on things to get back to everyone on. But I don't think we can create a situation where the third party has an independent obligation, because I just don't think that's going to work. I think that just straight up conflicts with HIPAA.
And a separate provision someplace else that makes it clear that no one acting on behalf of the provider can be treated differently or get around these, fee restrictions or the strictures of the statute is fine. As long, in my mind anyways, subject to what everybody else thinks, but as long as it covers both, that's the concern.
Okay. Next I have Rep. Conley.
Thank you. I'll start with a procedural request. I know we got this a little bit this morning, and when I opened it, I had a hard time getting to the track changes. So I had to download it onto Word. It could have just been that maybe a note that I need to update my CJ laptop. But if folks who are sending things, if you could also send a Word and a PDF, that would have just helped a little bit easier. Reading it through without the track changes, and I actually got the duplicate language with the crossouts and then the regular. So when I figured it out, it did make the bill make so much more sense. So just for the next person, if you can do the PDF and the Word, it'll help, especially if people are on a mobile device and maybe not on a traditional laptop or computer. just a couple of thoughts I had. I understand the need that some need for the color copies, but I think maybe we're putting the needs of some and assuming they're the needs of all. In a wordsmithing way, is there a way that we could do color copy by request so that if someone doesn't need the color copy, isn't requesting the color copy, they could get, if the black and white suffices their needs, they have the opportunity to get that as they need. Most of my work, I just need the black and white, and I'm thinking I don't need that. Other thing, the expedited, I see the reason why you put the statute to repose in for that expedited. I'm just thinking out loud. There are others who probably have other needs and may be okay with paying a price. Maybe they have a trial coming up and they need a record. Maybe they, for whatever reason, a deposition of an expert, something where they wanted to call and pay an expedited fee, which you can do now. I almost think that your desire to make sure we're not overwhelming may stop a current process. So if someone wanted to call for a deposition, an expert deposition, and get an expedited, or if there's a system for an expedited that someone's okay with outside the statute to repose, maybe for wordsmithing, how do we deal with that? And then I have no idea why the contact issue was there, but I don't think it's a current issue, so I'm glad you thought of that to remove that. I do see the issue with the federal and trying to get the records at a reasonable price. And I'm wondering if the complete record, acknowledging that some people need the complete record and others, let's say if there was a hospitalization, a surgery, and someone just wanted the operative note. By saying the complete record, is there a way that we're excluding those who are just looking for one thing? Because I know for someone who had a surgery and maybe someone needs all the nurse's notes, they really need the complete record. Someone else might just need a part. And how do we get that written correctly so that the person who just needs the part, maybe they only need 3 pages for their purpose. They're not paying the 65 cents a page for a 500-page record. Because if you don't need it, you don't need it. And that's their client's money and the staff of the hospital's time and money, so that we could still request just, the ER note if you needed it, the operative note if you needed it, the MRI if you just needed the imaging study. I do have, I know I use check boxes as to what I need to specify what I need, because again, sometimes you do need the complete record, but sometimes you just need a part of the record. And I want to make sure that everyone is getting what they need in a simplifying way, quicker and cheaper if possible. So that's my thoughts off the bat.
Okay. Thank you. Kyle.
Thank you, Representative Quinn. I want to first apologize. I had an IT nightmare this morning getting in, so I did not see the draft that was shared. I've heard a little bit about the language. I tried to use my phone to hear some of the YouTube testimony before I was actually admitted, but I've been into the actual meeting itself now for I think maybe 10, 15 minutes. I'd like an opportunity to review the draft in full, but some of the comments that I've heard, I want to make sure that we understand the distinction between a third-party request and a patient request. And this is something that I've said many times over the years, and it's a common misconception that when a third party is requesting the record, even for the patient's benefit, whether you're a life insurance company, whether you're a liability insurer, arguably all of those have some benefit to the patient because you're reviewing patient injuries and patient damages that at the end of the day is ultimately supposed to do something for the patient. There's a difference between a third-party request for the record and a patient's request for the record. HIPAA is designed to only govern the fees for the patient's request. And the patient's request, we're not concerned with any of the highly sensitive information that the patient wants to access and therefore we don't have to do the page-by-page review on all of that data looking for highly sensitive information. We do confirm that we are sending the patient only their records and not misfiling somebody else's record with theirs. But there is significant labor cost for the third-party requests, which go through a much stricter review. And we also have different mechanisms for delivery. We do have a patient portal that we use, but we also send the attorney or third-party requests to like life insurance companies, attorneys, through a different portal. So we have different methods of delivery with security measures to send those records electronically to each. I think we have to acknowledge that the labor cost for the third party requests are more intense. We have hard labor costs that we've established in Connecticut for employees that are doing this labor and reviewing every page of the record, looking for the highly sensitive information, validating the request documents. You know, under HIPAA, there are two separate sections. There's 508. It's actually 45 CFR 164-508 that Jennifer mentioned, that is for a third party request. And a third party request historically always required the HIPAA authorization, which has 9 elements and comments and notices that are provided to the patient, so they know, like, to address Representative Conley's point. She said, what if you only need certain pages? The authorization allows for that. It says what records are being requested. It also has checkboxes for releasing highly sensitive information. It has a notice that says you may terminate this authorization at any time just by providing notice to the provider and or to the person who's authorized to make the requests. It has information about what providers you're allowed to request records from. Whereas if a patient under section 524, that's 45 CFR 164-524, that governs a patient's request for their own record, which is an entirely different purpose. That is a patient asking for their own record so that they can take it to another provider, so that they can review their own medical history, so that they can determine their care. And those are treated differently under HIPAA. So when we draw this analogy and say, well, you can't charge any higher than the fees that the Fed established, well, the Fed established fees for patients and left state rates or third-party rates to the states. And that's why we have these state fee schedules in 43 of the states. And I think I can provide that. I think I already have provided some information, maybe I haven't, to the committee as far as what the other states have as a statutory fee schedule, both for paper and electronic. 21 states have separate fee schedules for paper and electronic. The remaining states have either paper or they may use just reasonable fee language, something of that nature. And so I think that we need to keep things consistent with these other models. We shouldn't be going down this road of every request has to be treated like a patient request, because that's not what HIPAA ever intended. That's not what the current law is. And so I just like to keep us aware of that and keep us on a path towards negotiating a reasonable fee for third-party requests that we're providing, and providing a good and valuable service, protecting patient privacy and getting the records into the hands of those who need them. And with respect to turnaround times, I know that the data that I'm going to share right now is probably, people are going to dispute it, but I asked for our attorney request turnaround time in the state of Connecticut, and it averages around 5 days. Now, I want to tell you, though, that when I say that, that is a response. It's not the actual record necessarily. So if we don't have all of the data that we need, if we don't have the authorizations we need, if we don't have the court order that we need, if we're missing something, then we have to send out a correspondence letter saying we need this. We close that file. So if we've sent that letter, that is our response time. That goes towards our average response time of calculation. So that may be contributing to that lower number that I'm sure. I mean, I saw reactions and heard some laughing, and I get it. I knew that was going to happen. But my point is, that is what we have in our system from when we enter it in the system to when we send a response, not the actual record. And I think you would all agree that many times we have to contact your office with a correspondence letter or a phone call or an email asking for additional documentation. That's fairly common. And so that's how we got that turnaround time of the net 5-day range. Thank you.
Kyle, just building off of that for a second. I know 5 days from when you enter it into the system. Do you have a stat as to how much time it takes from the point that you receive it before it's put into the system?
No, unfortunately, I don't have that data. That is something, and we talked about this in our the last meeting, where there is a disconnect between when a provider gets something and when it gets to us. And that is something that, like I said, Utah tried to address by saying we're going to require providers to list who their ROI vendors are on the Department of Health website. And so, unfortunately, the mail doesn't come directly to us. And I addressed some of those issues before, like service of a subpoena. That's still got to be served properly under state law. So that's not something that we could receive directly. Now, a typical just request for a record, potentially, and Jennifer, I'd like to work with her on this to see what we could come up with to where the providers would feel comfortable allowing third-party providers like your Verismas, MROs, Sharecares, and Cioxes to receive the record requests directly rather than sending them to the provider. And if the providers can get comfortable with that, maybe we can set up a system like that where you'd be able to send the request directly to the third-party vendors if you know who they are. And that would cut out some of that lead time before it would get to us.
Okay. All right. Thank you. Rachel.
Good morning. Thank you for Mike, Kathleen, and Rick for putting this out there and suggesting a first draft. One thing I think might need to go in here is that the 65 cents per page only applies to paper copies as opposed to electronic copies, because I don't think the cost would be the same there. Secondly, I think that there needs to be a more review around the authorization, the HIPAA authorization that we've been talking about, because my understanding is that HIPAA does not apply to workers' comp insurers. And I think that there is already a workers' comp Connecticut form authorization on the commission site. I've heard that some providers don't accept that form. So to kind of get to the issue we're trying to discuss here in regards to expediency, if there was a requirement in a statute that the Connecticut promulgated workers' comp auth needs to be accepted by providers, that could help with expediency in making the record and eliminating confusion about authorizations, and could help with quicker receipt of records. Thank you.
All right, thank you. Representative O'Day.
Thank you very much, Representative. Good to see everybody. I hope everybody had a safe and happy Thanksgiving. I had asked Kyle in the chat for a copy of those 21 states, what they've done for fees for paper versus digital, and thank you for providing that. I don't want to, I got to believe this has been done. And I will say, Kyle, I don't do much. I do mostly defense work, but I have had requested medical records, and Yale's third party out of Pennsylvania, it's weeks, not 5 days. Now I hear what you're saying. It's 5 days to send the letter. We've gotten your request, kind of like a FOIA request, but yeah, they did not do a good job in the experience that I had the one time as of late. But what I totally get to the third party cost versus the patient cost. That's good point. Never thought of. I'm wondering, do some states offer, like there was a situation where Yale tried to charge, or the third party wanted to charge $10,000 for a digital for copies, and it just didn't make sense to me that there wouldn't be some way that a patient could get access to medical records and a digital download, even if it's not for a third party, if it's for their own ability to go to a doctor and get a review. It just seems outrageous that the patient would have to be charged or pay $10,000 to get their records and a digital download to give it to another doctor. I don't want to put anybody in the spot, but is there a state that has tackled this digital issue, and what is a fair fee for that?
Representative Quinn, may I answer?
Yeah, go ahead, Kyle.
So yeah, like I said, there are 21 states, and I will provide that information. I will email everyone who's on the invite after I get unfortunately, my work computer back up and running. So those states take various approaches, and we had a couple of states just last session. And I can give you some numbers off the top of my head because I've worked on many of those states. Out of the 21 states that have separate fee schedules for electronic records, for better or worse, I've actually worked on 16 of those in the last 11 years. So I've got firsthand knowledge of what it's like trying to draft that legislation, negotiate the fees, and come up with something that the industry can live with. I can tell you that our costs are different in each state. You've got costs of living that are different in each state. You've got the numbers of employees, the training that's required. Connecticut is quite frankly a higher cost of living. Your taxes are higher there. So it costs more to employ people there to do the same work than it would in, say, Nevada, for instance, right? Now, that being
We're working
said,
on that, Kyle. We're working on it.
that being said, here are some examples that I can give you of how we would address this instead of just saying, hey, here's the federal rate, just figure that out and just bill what you'd bill the patient for the attorneys or third parties. I commonly see attorneys come into hearings with a $10,000 invoice, a $15,000 invoice, a $5,000 invoice. I agree, that's patently offensive, right? A medical record for that amount of money. So let's impose a cap. Let's say here's a hard cap. We're never going above X dollars. We've got to figure out what that is. But I can tell you of the 21 states, the majority of those 21 have established a hard cap for an electronic record. The next thing you do is you do not cap a paper record because paper records have supply costs. You also are incentivizing people to go to electronic delivery, which is better for everyone at that point. It's more secure, it's faster, there's less waste. So it's a faster turnaround, it's safer, more secure, and you'll get the whole record downloaded to your computer. So let's incentivize electronic. So no cap on paper, cap on electronic. Now let's figure out what the fee should be. If you're going to establish a cap, you already know that those patently offensive invoices of $10,000 aren't going to happen. So now you're just dealing with what are we going to pay for the original record? I would stipulate that in the majority of states, I think it's 37 now, there is what we call a search and handling fee, which you charge for the validating of the request documents, going over the authorization, going over the request letter, the subpoena, the court order, the estate documentation, a will if it's provided, whatever all that information is that's being presented, we have to go through all that and validate it. We've got to make sure that the HIPAA authorization meets the requirements under HIPAA. Like I mentioned earlier, there's the 9 required statements and notices that have to be given to the patient. If they're not in the authorization, it's not a valid authorization. And we would send a rejection letter out to that. So what the states have done, again, cap on electronic, but then for the electronic, states have taken an approach of it should be the same rate as the paper because you have a cap. States like Pennsylvania and Colorado are 2 examples of that. Some states have said you can bill a percentage of per page rates for electronic that you would bill for paper. Just an example for easy math, you may have 75%. So you'll say paper is $1 a page, then electronic would be 75 cents per page. So you're acknowledging that you're going to have labor, but you're going to reduce it because of, say, your material costs or your delivery costs, right? So you're reducing it there. A number of states have done that approach, like Illinois is one. Illinois is actually at 50%. Now their per page rates are a lot higher than your 65 cents, which I want to get to, but they will do a lower rate for that, right? That is another approach. And a third novel approach that I'm waiting to see how this plays out. But if you're all interested in this discussion, I am more than willing to have this discussion, but we need to be careful about the numbers because I know some of you are going to find it offensive. In Arkansas, last year, they adopted an electronic fee that is effective this year for the first time, flat fee of $75 for every electronic record request, flat fee. It doesn't matter if it's 2 pages or if it's 10,000 pages, $75. So that way you know what you're paying on every request, period. Now, I want to address one other point before we go on, and it is about that fee issue. I just took it upon myself to see when this original fee statute was established in Connecticut, and it was 1993. I did a CPI adjuster calculator using the U.S. Bureau of Labor and Statistics. That 65 cents a page in today's dollars would be $1.40 a page. I can guarantee you that your average settlements have gone up from 1993 till now. Your average paralegal salary has gone up from 1993 till now. Our ROI specialists' average salary and benefits have gone up from 1993 to now. But what hasn't gone up? That 65 cents a page. And we still have the labor cost. Technology has not saved us on the labor cost of reviewing and delivering the record.
No, and Kyle, if I think it's going to be very helpful to see what those states, particularly the ones that you were involved in negotiation, because look, we don't want the hospitals losing money on every search, but we also, like you said, the $10,000 fee is just outrageous in my mind. But I hear you. We haven't addressed the per page. That certainly, I think, should be part of the discussion. But the cap, I don't know. Arkansas. I mean, that sounds pretty good to me. But again, are the hospitals covering their costs at that $75 fee for whether it's 2 pages or 10,000? I don't know, and I want to make sure that the hospitals aren't losing a lot of money when they're doing that. So I appreciate that, Kyle. I'm looking forward to seeing what the other states do, so that we don't have to reinvent the wheel, so to speak, and make a fair compromise between for time, cost, and profitability for the hospitals, so they're not losing money. Thank you.
Okay.
I'd like-
Thank you. Yeah, Rick, if you have something just on this part of the discussion, go ahead.
Yes. I think that everyone should know that if we apply for the federal system and get a disc of a whole medical record, whether it's 200 or 500 or 1,000 pages, it's $6.50. $6.50. That's what it is under the federal system. In addition, for a search fee, there are 14 states that do not charge any search fee at all. Now, California charges a search fee. Guess what it is? $4, not 75, not 100, all right, not 1,000, $4 for a search fee. The search for a disc is you put it into a machine and the disc comes out, okay? And we have given options to hospitals to charge for the search fee, and they end up charging $6.50. So, and I think that the claim that the attorney should not be able, with the authorization of the client, to get the record is spurious and undocumented, and I don't agree with what Kyle is setting forth. What Kyle's setting forth is delay, delay, delay. And there was a question, how often do I use? I think that Representative Conley made an excellent point that we probably should do something to get records other than the statute of limitations. I thought that was a very good comment, and we'd be delighted to work with that. I sent out a letter yesterday telling a client that if I didn't get the full records by January 1st, that we were not doing the case. But I'm most concerned about this fee situation. I think it is without merit.
Okay. All right. Thank you. Let me go to Elizabeth, just because you haven't spoken yet.
Thank you, Representative Quinn. I just wanted to kind of chime in and weigh in. I saw Jennifer kind of shaking her head as well. Mr. Silver, I just wanted to address the federal system comment that you had made. The SIOX v. ACER case is, I think, has provided a lot of clarity in the matter in asserting that a patient personal representative, as defined at 164.502G, differs from a patient's attorney. So unfortunately that, we do have to handle those two requests differently, as Kyle had mentioned. Now, that being said, I can just say that our preference, I think, across the board is that we always want to provide you with the records as quickly as possible, at a reasonable price, according to state statute, and with it is minimal effort for you and for your clients. So I'm going to kind of step back for a moment and see if you have any response, or if Representative Quinn has any comments as well. So thank you.
Okay. Yeah, did anybody else want to chime in on that? Representative Conley?
Yeah, I just want to say with the quickness, I think an issue that still has not been addressed is getting the request to these third-party vendors. That if we talk about quick and we're just looking at the last leg of the quickness, we're not looking at the request from when it leaves the attorney's office to the record getting to the place that it was requested to. I think some of the comments that have been made have been just that snapshot of when it gets to one person's desk and out the door, as opposed to the full process of a request. So I know some people only have the data for their section, but I think that some of the reactions from others on the call are based on a response for a partial information. So if anyone asks for a record, it leaves their office based on email, fax, snail mail, and it gets received by a medical authorization, and then it goes to another location, who then sends I received the request letter, and then a certain amount of days later, a document, either a letter or a medical request, has been emailed or snail mailed or faxed back. I think we have to look at that acknowledge that the time is that whole process, not just the one step. And I think that's something that I still don't see a solution to, on what do you do when the third party provider doesn't have it and the person still requested it. I don't think we're coming to that solution in this. What do you do when it's been requested and the third party provider doesn't have it, and then the person asking for it still doesn't get it? We're kind of having that same situation that I think a lot of the frustration from people asking for medical records is. Your staff calls, we didn't get the request, you have to resend it. And we're back at square one. So I think that's where some of the frustration is. Thank you.
Thank you. Jennifer.
Thank you, Representative Quinn. Thank you, Representative Conley. That's a really good point. I think that without getting too deep into philosophy, this entire system is built like a Frankenstein monster, because back in the days when we went from paper to electronic, you're getting big folks with resources can have a full staff for HIM, health information management. You're getting other folks in the middle who can't. So you get some of the external companies, some don't, some process it to a certain point. And I'll tell you something that hasn't come up that is important from the providers and certainly from the hospital's point of view. Privacy and trying to systemize that we're sure we're getting privacy right has created all these formulas, this Frankenstein monster. So it's got to hit point A and then it's got to hit point B, because they would, frankly, rather you get the record late than violate somebody's privacy. And it's unfortunately, it's a machine, and it's a machine that's taken on its own weight. And in a perfect world, would any of us design it this way? We would not, but we have to work back from what we have. And I will tell you, if hospitals and providers are unable to use third-party services like SciOx, it would be an extreme cost to reinvent a system where they would have to do it themselves. And I'm not saying it isn't frustrating. It is absolutely frustrating for everybody. So that's a philosophical point. But I want to go back to something Rachel said a while ago about workers' comp, because it's important. I know we're trying to do both at once, everything and then also workers' comp. So it is true that workers' comp insurers do not have to do HIPAA because they are not a covered entity as defined under HIPAA. But workers' comp itself, as from a privacy and records perspective, does not escape HIPAA. HIPAA applies in several ways to workers' comp, which also creates some of this machinery and slowdown. So I agree with what Rachel said. It might be time to be sure Workers' Comp Commission and folks have got the right HIPAA compliant authorization, because under federal law, if you need an authorization for something, and in Connecticut you do, on the trigger for workers' comp after first report of injury, it has to be a HIPAA compliant authorization, 1. 2, the minimum necessary standard in HIPAA applies to workers' comp from the provider side. That is a rate limiting step on getting the information out. So you get some of this detritus we're talking about with regular records applies in comp as well. And additionally, the federal rule under HIPAA for workers' comp is that information can be shared, but only to the extent authorized or required by law. And as I think everybody who here knows comp knows, under Connecticut law, a patient, a claimant can bounce out if they choose, right? They get to a point in the system, or they don't even want to make a first report of injury. They don't want to use comp. That is their right. And that can switch at any time. So it can't just be an open ticket. There has to be some recognition that the information is within the authorized or required by law, which sometimes does require your whole medical history. Sometimes it only requires parts of it. That's what complicates the comp part. That's a much easier problem to solve than everything we're talking about with the example of the proposal that Mike discussed this morning. So just want to be sure that comp thing doesn't get lost, because I feel like there's a lot we can do to expedite and clean up the workers' comp stuff. It's a much easier bite to chew than trying to boil the ocean on the other stuff. And I just didn't want to lose that in the process, because Rachel made some really good points.
Okay. Thank you. Kyle.
I wanted to address a couple of very specific points that were brought up earlier. And I also wanted to let everyone know I sent you a spreadsheet just minutes ago of all the 21 states that have enacted electronic fee schedules. So you should have that in your inbox. If you don't, please let me know and I can send it out again, or I can send it to Nathan, who can then contribute or distribute it to the rest of the group. I want to address, Mr. Silver brought up California, and I think I welcome the opportunity to compare states to come up with a fee schedule. So I welcome, first of all, looking at other states. I don't welcome using California, and here's why. California's fee schedule was established in 1986 and has not changed since then. Also, there are two fee schedules in the state of California. There's section 1158 under the evidence code, and there's section 1563, which specifically governs subpoenas. There is a $4 fee, but it's $4 per quarter hour, which comes out to $16 an hour under 1158. And if it's a subpoena, it's $6 per quarter hour, which comes out to $24 an hour. Our employees in California make far more than that. We have tried to actually change the law in California. We have not been successful, but 1986, think about how much things have changed since 1986. HIPAA wasn't even a law then. I think Jennifer would confirm that. I mean, she's well versed in HIPAA. HIPAA came out in 1996 and didn't actually become law that was enforceable until the regs were implemented in 2002. We didn't have electronic health records in 1986. Everything was done with you would carry a copier into the medical records office and physically make a copy on your portable copier. So that is the fee that you're working with in California. We've actually had litigation in California where we've set up to be the agents of those who are requesting records so that we're not bound by those fees. And we've had courts that have upheld our process there. So I don't want to use California. If you want to use examples, let's look at the other states that I just emailed you, the 21, because I think those are reasonable fees that have been established in the last 10, 11 years that are post-HIPAA, that are post-electronic health record ubiquity, and that are applicable to what we're doing today. Thank you.
Okay. Mike?
Thanks. I just wanted to comment on a few things. Representative Conley mentioned timing and how do we address that? And I can't remember if it was a question that I had raised in one of our meetings or it was someone else, but I know that Kyle perhaps had responded to it, but the timing in my mind should be relatively simple. If there's a 30-day requirement from the time the request is submitted to the provider, then it should be 30 days. And if the provider delays in getting it to whoever their vendor is, then the vendor needs to be aware of how much that delay was so that they can respond appropriately within that 30 days. I mean, to the extent there's some contractual provision that can be established between the provider and the vendor to make sure that that situation is under control, seems to me it would be appropriate. The only way around that, as I see it, would be to establish some time requirement that applied to the provider and a separate one that provided, that applied to the vendor. But all we're doing is complicating things. So it seems to me that there should be a time limit. It should be simple. It should apply from the time the request is made. It should be tracked appropriately between the provider and the vendor. And if there has to be a penalty provision to incentivize the provider to make sure that transmittal is done timely, then maybe there has to be something to incentivize the transmittal of the request. I did want to ask Kyle a question, and this has to do with the difference between the workload that was described for a patient request versus a request made by somebody else, a third party. Let's just take a lawyer, for instance, and it could potentially be their authorized healthcare proxy, if you will. But let's just take a lawyer, for instance. If the client has authorized the lawyer to get their complete record, and it's appropriately set forth in the HIPAA authorization that what is requested is their complete record. I know that, Kyle, what you mentioned was that if it's the patient, all you do is make sure that the proper documentation was submitted with the request. But you mentioned that if it was someone else other than the patient, then you have to take additional steps for highly sensitive information. But if the patient submits an authorization where they allow a complete release of all of their records, including any highly sensitive information, doesn't that eliminate the labor for the search that would have to be done for that highly sensitive information? And then I have one other, let me just finish my questions and you can respond to them. The last one was, and this may not be up to date, so it's not up to date, Kyle, I apologize for that. And I also could be missing things because sometimes my eyes plays tricks on me. I'm looking at a matrix of the various states across the country that have statutes that apply to, fees. And I appreciate that some of these may be old, and you mentioned California. So I don't have any reason to disagree with what you're saying. But if I'm reading the summary that I have correctly, there is one state that applies a percentage of the paper fee for the maximum charge for an electronic copy. And the one I'm looking at anyways is Illinois. And their percentage is 50%. Now, there may be others, and my eyes may be playing tricks on me as I try to look through this matrix. But, in my mind, that's outrageous. That's outrageous. I mean, if you have a 5,000-page hospital record, and let's just say the per page rate is 65 cents a page, and the electronic copy is 50% of that, that's an outrageous sum of money. So this idea of a percentage of the paper copy as a cap for an electronic record, I think is that I would say is offensive. Having said that, I do have a listing of what other states have done in terms of maximum charges for electronic records. And it runs the gamut. It would require some better understanding of how they arrived at those caps. But, there are states that do have a maximum rate for an electronic record, and none of them are high. All of them are quite low, actually. But there is a maximum rate. So, but I wanted to make it clear that the percentage of a paper copy, at 75% was the example that you had given. I mean, that's an incredibly astronomical charge. But what I really wanted to hear is, what's your thought about how do we address this timing issue? And if there was a carte blanche authorization that a lawyer submitted that would allow the lawyer to get all information, including highly sensitive information, how does that affect your labor costs?
Thank you for the question, Michael. I appreciate the thoughts. And just to clarify one point on the fee issue, you are right. Illinois is one of the states that has just the percentage of the electronic fee as a percentage of the paper per page rate, and they do not have a hard cap. But the majority of states have a combination or apply a combination where you have a hard cap on the electronic of, say, like $200. Oklahoma is a good example. Oklahoma has a $200 cap, and then the electronic fee is a percentage of what the paper fee is. So Oklahoma does both of those tactics. They take a percentage of the per paper fee for the per page, and then they also apply a hard cap on the electronic and no cap on the paper. So you all can take a look at the spreadsheet that I sent you. I want you all to be aware too that there's a lot of nuance to this business, and this is an oversimplified document that I sent you, because workers' comp is regulated differently in some states. Disability is regulated differently in some states. Some states, like New Jersey, defense attorneys and plaintiffs' attorneys are treated differently. So, I mean, there's a lot of nuance here. What I say to you is the general third-party request fees for electronic records, so that you would have some guidance as to what's been going on in the industry lately. Now, with respect to your labor question, I think we have to first understand that electronic health records are not set up. And if we, Representative Quinn, I'm going to offer this now. If we would like to do an on-site visit so that we can see how an electronic health record works and what our employees have to do, we can potentially set that up. I would have to talk to our operations people, and I don't think we could do the whole group, but we could take like limited representatives to be able to go in, like one person from each of our segments here, to go and take a look at this and do an on-site visit. We'd need to have everyone sign a BAA because you will be seeing, PHI at that point. We need to make sure that that's protected. But I think that it would be valuable for you to see how an electronic health record is set up. And when we get a third-party request, we're going to have to go into, like we discussed in last meeting, multiple EHRs. We're going to have to sign in and sign out of each. You're not allowed to leave under, hospital policy. You're not allowed to leave an EHR signed in while you're going into another EHR. That's a potential security risk. So you've got to go in and out. You've got to check each of the EHRs that you have for that provider. If they're in a health system, you're going to have more. You could have the legacy systems that Liz mentioned on the last call that we had. Then when you go into an EHR, this is not as simple as, let's type in Kyle Probst and his record is there. Okay, there's the whole record, copy, paste, done. These records are broken out by the category of record that they are. Sometimes they're broken out by date. So you're going to have to go in and see the requests and what you can fulfill and match it up with the different categories of records. And when you open each of those independently, so it's not like it's one click and drag. And I think that's one of the common misconceptions. Everybody thinks Kyle Probst, click on his name, boom. Okay, copy, paste, put it in a file folder, I'm done, next case. That's not how it works. There are going to be multiple entries for each one. If you've ever gone into what's called MyChart, like if you have a provider that has like Epic and you use MyChart, if you go into your MyChart, isn't it broken out by like radiology report, medicines or prescriptions? Then it'll have like admission records, then it'll have insurance records. Each of those are itemized differently. They're done the same way in an EHR, only it's more complicated. MyChart is, dare I use the phrase, dumbed down so that anybody and everybody can use it and follow their medical record. But when you go into the EHR, it's a much more complicated scheme than that. We're still going in, even on a patient request, we're still reviewing every page because we want to make sure we're not sending John Doe, Jane Doe's records that happen to be misfiled. So we still are comparing the names and dates of birth. We're matching identifiers, but we are not looking for highly sensitive information. Because like I said, a patient's entitled to their entire record, even the highly sensitive info. They don't have to sign an authorization if they want their own record. But for the third-party requests, not only are we looking for the highly sensitive information, which I understand in your example, you said, let's assume that the patient checks all those boxes. So now we're not screening for highly sensitive. What we're still doing, though, is going in and matching those identifiers in each page of the record to make sure that there aren't those misfiles. So the labor is still there. The labor is still there and going into each of the, radiology reports, prescription reports, surgery reports, all those different reports. We're still going into each of those independently, as well as the independent EHR systems that we have to sign in and out of.
Can
I just answers your question?
Yeah, well, let me just follow up with one question if I can. My question really was, how does the labor differ? I mean, if a patient requests their record directly and you're not screening for highly sensitive information, presumably you're making sure you're not mixing up another patient's records, but you're still presumably going through the work that you just described to make sure that the patient gets all of their complete records. So if a lawyer were to do the same thing, submit a request, it checks all the boxes, you don't have to screen it for highly sensitive information, aren't you doing the same thing? In other words, isn't the labor the same? What I'm trying to figure out is, how is the labor different if you get an appropriate authorization from a lawyer?
So yes, and I understand your question, and I would say that the labor for reviewing every page of the record is going to be the same in that scenario, right? Here is the fine point we have to draw, is that under HIPAA does not permit you to charge for reviewing and protecting the patient privacy of every page of the record. HIPAA only allows you to charge for the reproduction, the physical reproduction cost. What does it take to turn page A into copy A1 for the patient, right? So that's what we're able to charge under HIPAA. We're not allowed to do a search and retrieval. We're not allowed to charge for validating authorization and request documents. We're not allowed to charge for offsite retrieval. We're not allowed to charge for the review of the record and validating for patient privacy or highly sensitive information, right? Those are limited under HIPAA, but they are all elements that are necessary towards the state fees for sending to a third party. So that is how your labor is significantly different, if that makes sense.
Yeah, so it sounds to me like what you're saying, and you correct me if I'm wrong, I'm just trying to get an understanding of it. You're essentially saying that you're losing money when you respond to patient requests directly, and that with requests from lawyers or others, you're hoping that you can actually make money. I guess I hate to dumb it down like that, but it sounds like I mean, I understand what you're saying, and I think I understand it.
Yeah, I'm, if we're putting all our cards on the table, you're absolutely right. That is exactly it. And I will address that $6.50 that OCR came up with in 2016. That $6.50, I happen to have personal knowledge. I believe it has never been confirmed, but I know for a fact we had a contract with a provider that was audited by OCR back in 2013, and we had to produce a contract for that provider. And that provider's contract had in there that was a negotiated at arm's length transaction between a vendor and a provider, that if we produce a patient's record, then we would do it for $6.50 if it was produced on a CD. So that became de facto what OCR said, oh, that must be reasonable for the entire country, the entire industry. We'll use that number. So that's where that $6.50 was not the result of a time study. It was not the result of a cost study. It was a number that was fully negotiated between two parties in an arm's length transaction and a contract for a patient's request for that specific provider.
Representative Quinn, may I follow up with just one final question?
Yeah, if you could, thank you.
All right, so Kyle, just that my final question had to do with the timing. How would you propose that the timing be addressed? I mean, last we spoke, I think you had, said that your records only really document when you responded, not when the request was submitted to the actual provider. So what is I mean, if you have a 30-day requirement from the time the request is submitted to the provider, then how can in your world make that 30-day work?
I have to be honest with you. We're going to have to see how Utah plays out, because I don't have any clear answers to that. But I do think, and Michael, I think you were the one who brought up a different standard for a provider and an ROI vendor. And that is the approach that Utah is attempting to use with their 2023 legislation. And they say that a provider has to get the request to their vendor within a certain amount of days. And if they don't utilize a vendor, then they have to respond within a certain amount of days. And it also says that if a vendor gets the record, they have to produce the response within a certain amount of days. And then there is a penalty provision, which I understand you talked about a penalty provision. There is a penalty provision built in of you're allowed to collect 50% of your fee that you would have billed had it been a timely response. And if you're 60 days or more, then the record must be produced for free. But there's no penalty as far as like a fine or anything like that, or attorney's fees or anything like that. It's just you don't get the fee that you would be required to get under law otherwise, right? I argued with the Utah the people I was negotiating with there, saying, I don't really know, like if you just have a provision that says after 60 days it's free, there's no incentive for us to deliver it on 61 or 65 or 110, right? So I think that, and quite frankly, we want to get you the records. We're holding back the records when we have privacy issues or validation of authorization issues, right? Because it behooves us to get the records to you, because that's how we make money. So this concept of we're sitting on records or we're holding them back doesn't make any sense to me, because if we get records out the door, then we hopefully get payment. I mean, for us to have good turnaround times is good for business as well as good for your clients. So I struggle to understand, and that's why I think that there's got to be some disconnect between an understanding of how we measure turnaround times when we send out a correspondence letter saying we need this to be completed or that to be completed, and when the provider gets us the request so we can execute it. I think there's a disconnect on those two fronts. And if we can look at the Utah example, I can send a link to that law as well, so we can see what Utah did last session. But I want to caution you that I don't know how that's going to play out because it is so new.
Okay. All right. Thank you. Marie.
Yes, good morning, everyone. Most of the discussion that we've had this morning has to do with civil litigation, med malpractice. Jennifer has mentioned workers' comp a little bit, but I just had a couple questions with respect to where this proposed legislation might be going in terms of the workers' comp forum. Last year, the proposed legislation, it seemed more directed towards us than this does. So maybe the representatives on this call could address that. Also, there's in the proposal that came from Attorney D'Amico this morning, there's nothing about penalties. Last year's submission or proposal before the legislature did talk about penalties for late receipt of records. So I was hoping that someone could comment on that as well. And then just as an aside, I wanted to mention specifically in response to something that Jennifer Cox said, is that we are actually in the middle of revising the authorization, the workers' comp authorization, trying to make it a little bit more all-encompassing. That hasn't come out yet, but it's probably going to come out soon. So if someone could just comment on where we're going with workers' comp, I would appreciate it.
I think where we're going to go with workers' comp is obviously Section B of 31294F is rather sparse. Obviously, I mean, I think on the civil side, the penalty of a reduction in the fee or elimination of the fee if the records aren't timely produced makes some sense. On the workers' comp side, we're already not being charged for them, so I think we would have to come up with some sort of a penalty system if we were going to go down that road and enact one. So I think that Rep. Conley and I will probably have a conversation about 294F and what changes we think should be proposed to make the records gathering process simpler and more expedient. If that answers your question, Marie.
I guess. So basically the answer is stay tuned.
Yes.
Yeah. Okay. Thanks, Mike.
You're welcome. Tom again?
Yeah, sorry. Thanks for the second time. Just a couple quick things. Mike, there's nothing in the proposal that I read that you sent around about digital versus paper or any caps or anything like that. Is that something that you're all willing to look at? I assume the answer is yes.
The answer is yes. The reason we didn't set out, and we probably should mention in the 65 cents a page that that's limited to paper. We didn't think it was necessary based on the whichever is less language when you use 65 cents a page or what's allowable under federal law, although there was some good commentary today that we should take back with further review to make sure that it's clear that the charge under federal law is what we really think it is under federal law. And it sounds like Jennifer and as well as Kyle have questioned whether or not the way this is worded makes it clear what that language is actually referring to. And by that, I mean the dichotomy between the quote unquote patient rate on the one hand and that which is charged to third-party vendors on the other. Having done a lot of research on this issue over the years, it seemed to me that it was a little bit more blurred than that, and the SIOX decision and its aftermath haven't really helped all that much. But it sounds like that needs to be thought about a little bit more and make sure the verbiage on it is accurate and clear. And to the extent it requires what you're suggesting, some specific reference to digital versus paper as part of that, then it certainly makes sense.
I mean, just listening to Kyle, what you were stating, I mean, Oklahoma, I haven't had a chance to review your spreadsheet yet. I don't know if I've gotten it, but Oklahoma sounds appealing to me. Do any state stagger the fee based on the time requested to get the records? In other words, like court reporters, overnight, it's $7 per page, whereas if you can wait 2 weeks, it's $1.50. I'm not suggesting that's where we go. I'm wondering if any other state does that, because that may be a way that the hospital can make up some cost of expediting it. And then the patient or the third party can pay a higher fee to get it quicker. I'm just throwing that out there. I don't know if any state does that. And then, I guess, Kyle, if you could answer that. And then Jennifer, you had put in the chat that it would be extraordinary for Connecticut to adopt the law based on Utah's medical records decision-making. Just wondering why you said that. Unfortunately, I lost the argument on why we base our admission standards on California law. So there's a lot of things we do in Connecticut based on other states that sometimes I'm not happy with. But in any event, so just wondering what you meant by that, Jennifer and Kyle, if you could just address those two questions I had for you, that would be great.
So I'll just
go ahead, Jennifer.
Real quick. Utah is not a place that values privacy or reproductive health rights or gender affirming care rights like Connecticut does. It's a lot easier to get a record out in Utah where there's a lot fewer things to look for. So I immediately bristle at using something that has an entirely different streamlined process. As Kyle noted, it's not the same. And it's also, Kyle hasn't said, but the labor cost is wage index based from national labor standards. And the labor cost in Utah is not the labor cost in Connecticut. That's how that is determined. So I think Utah is a poor example from apples to apples. The concept of separating paper from electronic, separating caps on one or the other, that is something we can work on the details. But I do not think Utah is a plug and play for Connecticut when it comes to medical records privacy.
I now I understand what you're saying. Okay, thank you. And Kyle, sorry.
If I can add one statement on to Utah, let's take a look at their two things that make them interesting from that comparison perspective. Is that Utah also has a $33 search and handling fee. Connecticut currently doesn't have one at all. And Utah also applies a CPI adjuster to their fees annually. So Utah acknowledges that the cost of things is increasing, and therefore the cost of producing these records and their fees that correspond with that should increase as well. Now, Utah does impose a cap on electronic records, but the cap increases based on CPI annually as well. I'd also like to mention that there's another thing we haven't discussed. Connecticut has a 65-cent per page fee, and that's it. That's all it says. There are states that establish tiered fees. So you'll have like 1 per page fee for pages 1 through 50 or 1 through 100. And then you have a lower fee for pages, 101 to 200. So we can tier the fee so that the higher pages don't just continually drum up the overall fee that you will pay as well. Regarding the question about, and I believe I remember the question, regarding the question about having like an expedited fee, there are a handful of states, probably less than 5. I think Indiana is one. I think maybe Louisiana is another, where if you request a record within a certain amount of time, and if the vendor or provider provides it within that time, there could be an expedited fee. And I think the range is around $15 to $25 if you meet those time requirements, but there's no penalty if you don't meet those time requirements. Now, obviously, we would like to, try and prioritize those to get that revenue and also to make the customers happy. So if we wanted to look at that, we potentially could. But again, there's only a handful of states that actually do that. And then we would have to clarify what is intended there. Is it just a response or is it the actual record? Because like I said, we track when we send a response out if there's documents missing that we might need. I'm sorry, what was the other question? It just slipped my mind now.
Yeah, no. Just the staggered fee, like court reporters do.
Yep.
And then what state? What state do you believe is that you were involved in that is the fairest between the needs that you're hearing of the lawyers, the third parties, versus the patients and the hospitals?
So I would have to look to see what the financial situation is like in Connecticut and compare numbers and requests and things of that nature. I don't think that there's one state that I would say, let's do this, right? I think what I would prefer to do is discuss a model and say, let's apply the model, but figure out the numbers separately, right? Let's see what numbers work for the state of Connecticut for us to continue to do business. You mentioned before, we are for-profit companies. That's nothing private. Everybody knows it. So we're going to want to have some profit built into this, obviously, but then figure out what numbers work. And I think a model that is structured with having a cap on electronic, no cap on paper, distributing the costs of the electronic per page fees are maybe less than the paper per page fees makes sense. Now, what numbers we come up with, whether we have a tiered system or not, I know Representative Quinn said something about workers' comp. They don't pay for records right now. Maybe, and I hope this comes across properly, but maybe
don't say it.
If everybody pays a little, then nobody pays a lot, right? So maybe we distribute that more and then we can negotiate what the actual numbers would be. I think it makes sense because, when people are getting things free, somebody's paying something, right? So I'd like to discuss that at least and have that discussion of what can we do with these fees and make them reasonable for everyone. And I think that imposing the cap is one of our, that is like with respect to the fee issue alone, imposing the cap on the electronic is where we start, I think.
All right.
Thank you very much. Thank you. Thank you, Mike.
Thanks, Tom. Right. We'll go to Rick and then Rachel, and then I think we'll call it a day.
I'd like to make just some short comments. First
Sure.
of all, our 14 states, including the state of New York, which is one of the largest states in the country, no fee, not even $6.50 search fee. In addition, Florida says for non-paper records, that's digital, total cost shall not exceed $2. Maine says $5 for paper only. New Jersey says $10. So when you talk about percentages, when the federal system, no matter what Kyle says, if I order it through the federal system tomorrow, it's $6.50. And one of my major concerns about these corporations, there's a 30-day limit. It's very, very rare that we receive any records in 30 days. Mostly it's towards 60 days. Our firm hires one person whose only responsibility is to call these companies and physicians and hospitals to get records. That's her only job. So we're very concerned about the delay in the response of records. If the proper job is being done, there's no excuse for not producing records within 30 days. That's my only comment.
Okay, thank you. And Rachel.
Thank you. I just wanted to make sure I understood. Were the changes proposed to 20-7C because there's a workers' comp guide out there that references 20-7C? Is that why the changes were proposed by everyone there? Mike and Kathleen.
I'm not sure I understand your question. The changes of 20-7C were proposed outside of the issues related to workers' comp. I mean, for everything else, so to speak. I'm not sure if that addresses your question.
So there is a guide right now called, it's on the Connecticut site, called, has a long title, so there would be Professional Guide for Attorneys, Physicians, and Other Healthcare Practitioners. And look at the State of Connecticut Workers' Comp Commission, and it references 20-7C. So I guess I thought that because, you know, this committee is focused on workers' comp, that's why the changes were proposed there to 20-7C versus within 31.
Yeah, I would defer
Okay.
to someone who has a workers' compensation practice. We don't handle workers' compensation, so but it wasn't, these changes were not proposed with workers' compensation in mind.
Yeah, and neither was the original bill that Representative Blumenthal had put forward. When it came to judiciary, that was where it was my thought that we really needed to loop workers' compensation into this, mainly on the timeliness factor. And with everything in workers' compensation being dependent on the receipt of a medical record, it's an unintended penalty for an injured worker who can't get a benefit because of the delay in getting the record. And there's an unintended penalty against an insurance carrier who might be able to cut off a benefit sooner if the record came out sooner, allowing that to be done. So that's how workers' comp has been tagged into this. And Kyle, one last comment, and then we'll adjourn for our next meeting.
Thank you, Representative Quinn. I'd just like to address 2 or 3 of the laws actually that Mr. Silver pointed out. New York has a 75-cent per page fee that was established in 1991 and has not been updated. That, just like California, is pre-HIPAA, pre-high tech, pre-ubiquity of EHRs. So we have a site from California from 1986, a site from New York that's 75 cents a page that is from 1991. Then the Florida law does mention $2 for something that is in non-paper format. However, we have argued in court and been successful thus far that fee, if you look at the legislative history, the $2 applies to microfiche only. And what happened is that when the legislature amended it in 2001, they didn't carry over the microfiche language because there was a cross-reference. So that does not apply to an electronic medical record. It applies to microfiche. And so that $2 is replicated in the microfiche statute, and it was a reference to that. And so that's where that $2 comes from. With respect to New Jersey, it's no longer a $10 search fee. The legislature amended that bill in 2023, or amended that law. It's now a $20 search fee. So that is outdated law that Mr. Silver has looked at. The proper law now is $20 search fee in New Jersey. And that applies for any third-party request for search and handling.
Okay. All right. Thank you. I think this has been a great discussion today. You know, what has been put before us is not gospel, but it's a first step. So I would encourage anyone who has a completely different idea on this to create a proposal similar to what the attorneys have done, or take their proposal and make some changes, expand on it, take some parts away. And as I indicated, Rep. Conley and I are going to look at the workers' comp statute and have something ready to have a discussion on that for our next meeting. So our next meeting would be December 12th. Again, it would be 10 o'clock in the morning. Any alternative proposals, other ideas, if you get them to me or Nate or Christine as soon as possible, we can get them out to everybody so that we'll be in a better position to have another discussion next week. But again, I think this was a very productive meeting. I appreciate all the different points of view that were expressed today, and I still remain confident that we can come up with something that everybody would find palatable. So with with that, if I could have a motion to adjourn,
So moved.
second. All in favor?
Aye.
All right.
Bye.
Thank you. And again, we will see you back here on Zoom on December 12th at 10 o'clock. Thank you.
Thank you.